Our next speaker is Dessa Reimer, joining us to talk about recent NEPA debt ceiling and regulatory amendments. Dessa is an attorney in the Jackson office of Holland and Hart, where her practice focuses on federal environmental regulation and litigation before the Interior Board of Land Appeals and the federal courts, including environmental impact assessment, endangered species, and public land permitting requirements. Please help me welcome Dessa.
Thank you so much. I'm delighted to be back in Laramie again for this conference. It's been a few years since I've been able to attend in person, and so it's wonderful to be here among colleagues and friends who are all interested in these similar issues. And today I have what I think is a really exciting topic. I see a few NEPA nerds in the room. I count myself among you. So this is a really exciting time for NEPA because for the first time in 50 years, we have substantial amendments to the act itself. And that is the first part of my presentation, is to walk you through those, get you up to speed on what the changes are that came out in June in the Fiscal Responsibility Act. And the second part of my talk is going to be on the Council on Environmental Quality's proposed rules. The comment period for those phase 2 rules just closed in September. And they are there's a lot to digest in those rules. I'm not going to get to all of it, but you'll see in my slides, I do reference the regulatory sections in the Code of Federal Regulations. So you can go look those up. And I highly recommend, if you're going to take a closer look, to grab the red line between the 2020 rules and the proposal, because that's where you're going to see it's going to be the easiest to digest in terms of what the changes are. So Rob Mathis is going to laugh at this slide because I am assuming that most people in this room have some familiarity with NEPA. So I put my background on what NEPA is onto one slide. Now, I know that we spend 2 days for the Foundation for Natural Resources and Energy Law, putting on special institutes on NEPA. So I tried to think, what do I want to put on this one slide? And I think what's important for everyone to kind of understand and put in context what the new rulemaking in particular is attempting to do is that NEPA is a procedural statute at its base. Its 2 key goals are informed public participation and decision-making, not directed decision-making. And we're going to see that play out a little bit in the direction that the new rules are going. And that action forcing provision for preparation of an EIS, an environmental impact statement for major federal actions with significant environmental effects, is that deceptively simple terminology in NEPA that really has engendered or been the basis for decades of litigation and judge-made definition around what that means. So it's that litigation and really the 50 years of better defining what's required by the agencies when they undertake a NEPA analysis that's led to increased complexity in the evolution of these documents, length, and of course the time. And I think we can all agree that it's that increase in time that has led to concerns about the inefficiencies of the NEPA process for projects across the board. We're not talking about just fossil fuels. We're talking about renewable energy projects and, of course, the infrastructure projects that are critical to the clean energy future that we've been hearing about today, including those carbon pipelines. So it's the recognition of those inefficiencies that agencies, that the executive branch has been attempting to address through executive orders for a number of years, but we're now seeing lead to the Fiscal Responsibility Act and Congress trying to tackle that. It's not the first attempt, though. We do have CEQ regulations that reforms that have been going on. And so the phase 2 rule proposal is what we're going to talk about today. The first regulations for implementing NEPA by the CEQ were promulgated in 1978, with the first major overhaul in 2020 under the Trump administration. In 2022, when the Biden administration came into office, one of their first goals was to take another look at those NEPA regulations and maybe turn back the clock to look at some of those that they felt should not have been enacted, were not in keeping with the purposes of NEPA. 3 of the most important issues were addressed in the phase 1 rollbacks in 2022. The purpose and need went back to the 1978 definition. The definition of effects was restored, including that concept of cumulative effects that's been developed in the case law and has been in the regulations for so long. So that went back into the regulations. And the CEQ regs are now, again, recognized as the floor and not the ceiling for NEPA compliance. And so we're going to talk about the comprehensive update of what CEQ is working toward today. I actually don't see a clock in the room, so I apologize. I just want to make sure that I don't overstay my welcome, so Alex has time to discuss these issues as well. Okay, so let's dive straight into the Fiscal Responsibility Act amendments. And Section 102 is that action forcing provision. So this is what requires the EIS, and really the changes that were inserted here reflect what was already in the regulations and is developed in the case law. And so you see that definition of effects being qualified as those that are reasonably foreseeable. And the idea here is that the agency doesn't engage in a crystal ball inquiry. It's not required to consider hypothetical or highly speculative impacts. And now we have that codified in NEPA itself. Also, there needs to be a reasonable range of alternatives. And the act now includes what was already in the case law, that a reasonable alternative needs to be one that's technically and economically feasible. And when you go back to the purpose of NEPA, this makes a lot of sense because it's supposed to lead to better agency decision-making. And if an alternative is not within the jurisdiction of the agency to implement, or it's not technically and economically feasible, it makes little sense for the agency to spend time analyzing the effects of that alternative. So now we're seeing that in the statute. The agency also has to, in the no action alternative, consider the negative impacts of not undertaking the action. For a number of decades, the no action alternative effects analysis, if you looked at it, was very pro forma. It basically said, without this activity, there won't be the environmental effects that are predicted under the proposed action. And now the statute is asking the agency to go one step further, because as we know, if one project doesn't take place, that may have reasonably foreseeable consequences in the business world or in practical terms. One example of this is if you look at the BLM's new addendum for leasing, for federal oil and gas leasing, there's a discussion in there that even without federal leasing of oil and gas, demand is not expected to change. And so what you will actually see is the continuation of the development of oil and gas on private lands, and also replacement potentially with energy from foreign sources, which could have the same or additional effects. So it's basically asking the agency to take that extra step. What is the practical effect of not implementing the proposed action? Section 106 addresses those threshold determinations of what is subject to NEPA. Of course, if it's not a final agency action, no NEPA. If it's categorically excluded, you don't have to prepare a NEPA document. An action with a clear or fundamental conflict with the statute. And this generally occurs where you have Congress directing that an action take place within a certain amount of time, and it's practically impossible to comply with NEPA. So in those instances, the agency doesn't have to, and that's now spelled out in the statute. And now for the first time in NEPA, we also have an acknowledgement of the EA process that was set out in the regulations and was never codified in NEPA itself. So now we have the statute itself acknowledging environmental assessments as another level of NEPA review where there are not reasonably foreseeable significant effects. Section 107 is one of the most significant changes, I would say, to the Act in a couple of respects. First, there's the requirement of one lead agency. That was already in the regulations, so this isn't some sort of stunning development. But it is the requirement that the lead agency coordinate not only with other cooperating agencies, but with the applicant in development of a schedule for the NEPA process. There's also the requirement that the agency produce one document to the extent practicable to address all the federal authorizations. So the cooperating agencies need to work together to make sure the analysis covers the environmental impacts that are critical to their decision-making process, that nothing's left out, one document is completed. The documents themselves have page limits. These were in the regulations, but there is no exception to these in the statute. So an EIS needs to be 150 pages. If it's extraordinarily complex, it can be up to 300 pages, and an EA can be 75 pages. Of course, the devil is in the details here, because what the agencies basically have done is moved a lot of the technical analyses, the more detailed discussion, to appendices. Because, for instance, with the new Rock Springs RMP, if those of you who've had the pleasure of reading that very lengthy document, the EIS itself may be only 300 pages, but there are hundreds and thousands of pages of technical appendices that are necessary to explain some of the important issues. But I do think that this, isn't an empty goal, because what you do want is an EIS that's digestible by the public. And you want one that the decision maker too could potentially sit down and read in a setting and get sufficient information to make an informed decision. So now we have those page limits codified. This is one of, I think, the more important changes, and we'll see how this plays out. Section 107 now endorses a sponsor or applicant prepared environmental document. This has been allowed for EAs in the CEQ regulations since the beginning, and it was extended to EISs, but we haven't seen agencies or applicants really taking this upon themselves. But now we see it in the statute itself. And the whole purpose behind this, as you can imagine, is that a project applicant is going to be motivated to get the document done in a timely manner. But this could be a really sticky situation. The applicants have to be careful here, because at the end of the day, it's that agency that has to adopt the document, and it has to comport with what the agency believes is required for NEPA. So to the extent a project has really sticky issues about the scope of the NEPA, the scope of cumulative impacts, those types of issues, you're going to have frequent and important conversations with the agency. And so whether this really speeds the process is unknown, because if an applicant just goes off and prepares an EIS and submits it to the agency, it's very likely that the agency is going to send it back. So I kind of think about this process as maybe more useful to those projects that are done with sufficient frequency, that the documents are fairly well crafted, and there's not a lot of controversial issues surrounding the document. And in those instances, it might be an efficient process for the applicant to take this on. The next addition from the amendments are deadlines. And these were in the regulation as well. And I think Alex is going to touch on these in his permitting reform talk. So I'm not going to get into these in too much depth, but you can see 2 years for the EIS, 1 year for the EA. I think one interesting question is the trigger date. For rights of way, it's pretty self-explanatory on the day that the agency notifies you that the application is complete. For all other actions, it's either the earlier of the day on which the notice of intent was issued, or the agency determines that NEPA requires an environmental document. Arguably, that second one, the determination follows the notice of intent, because if a notice of intent is going to issue, then presumably the agency determined that NEPA was required at some earlier point. And so I think the upshot of this is that agencies are likely going to have to put in place some sort of standardized determination letter or methodology, probably agency by agency, so that they don't end up in a situation where they're in litigation about when this time frame should start to run from. And of course, there's exceptions to the deadlines. And so they potentially in this case, swallow the rule. One interesting addition to the statute is that to the extent the agency decides to extend the deadline, it does need to be in consultation with the applicant, and only so long as is necessary, deemed necessary to complete the process. So there is the potential that applicants will be more involved, kept better informed of that process, and potentially have a voice in the schedule. Where an applicant believes that the agency has gotten off track, they don't have to wait under this court petition process until the agency misses the 2-year deadline. The way that the statute reads is that failure to act in accordance with the deadline is sufficient to file a petition. So arguably, if the agency fails to meet some milestone in a schedule, that would be an opportunity for an applicant to go to court and petition the court to put a deadline in place. But of course, can the court, give any sort of meaningful assistance when the agency could then just turn around and give itself that extension of the deadline? Just a few more points to make about the FRA amendments. Section 108 covers programmatic EISs, and it codifies that general rule that was in the case law that an EIS is good for about 5 years. If after 5 years you still intend to rely on a programmatic EIS, the solar or wind EISs, for example, the agency needs to assure itself that no supplementation is needed. Section 109 endorses the process of one agency adopting the categorical exclusions of another agency. And then Section 111 has a good definition of major federal actions. So major federal actions are the trigger for NEPA compliance. And now under the statute, excluded from that definition are actions with no or minimal federal funding, or with no or minimal federal involvement. In the CCUS world, that means that to the extent you're getting a loan guarantee for a project, the Act actually excludes that as a major federal action, so NEPA would not be required. But if you're going to have a major grant that you're bringing in for your project, that is the type of action that probably would require NEPA compliance. I also see this addition as Congress's rejection of the small handles doctrine. So for those of you who know NEPA, that is basically the idea that a project that is not federal but has a small federal authorization that might be required. The typical example would be a long linear infrastructure project that requires one Corps of Engineer crossing. That doesn't necessarily federalize the entirety of the project for NEPA purposes. And so I see Congress is endorsing that idea and rejecting the small handles doctrine. Okay, so we'll turn to the phase 2 rulemaking. And as I said, it's very extensive, so I'm not going to cover everything, but some of the more significant points. This slide and the purposes behind the rulemaking actually come from a CEQ presentation that I saw, and I pulled this directly off of the slide deck from CEQ. And I think that 5th bullet is perhaps the most important and the one that I want to focus on, and I think shows up throughout the regulations. Because as we know, NEPA is a procedural statute, but one of the purposes that CEQ has stated is that the changes are to facilitate environmental, climate change, and environmental justice outcomes. And we certainly know that NEPA, by requiring consideration of environmental issues, has led to better environmental outcomes, but that does seem to be a more explicit purpose now in the regulations. So let's just talk about some of those changes. They really are more than a rollback to 1978. For the agencies themselves and as a regulated industry, there's a lot of new things to digest, and I'm going to talk about some of the items on this slide as we move through this, but it's not just a regurgitation of the 1978 rules. On that point, of moving more from procedural to potentially substantive outcomes. Here's just a few examples of how the regulations seem to be pushing towards that approach. One is there is the elimination in the purpose section of the language that NEPA is a procedural statute. And the agency, when they talk about why they removed this, said it doesn't need to be said, it's just known. And while that may be true, I think there wasn't any harm in stating it in the regulation itself. There's also a requirement for identification of the environmentally preferable alternative. The way that the environmentally preferable alternative is defined is the alternative with the maximum environmental benefit. And there's some question here, and when you ask yourself, what is the preeminent environmental concern that informs the agency in identifying this alternative? And it seems to be that the agency is pushing for consideration primarily of climate change issues and environmental justice issues as the ones that should be considered most heavily in determining what that balance is in the environmentally preferred alternative. So for example, if you have a geothermal project that is going to replace a fossil fuel energy, it's going to have 24/7 renewable energy, and it's going to reduce carbon emissions. But the construction of that project could affect a spring where an endangered species is located. When the agency has to identify that environmentally preferred alternative, which of those environmental impacts takes precedence? And I would argue that the CEQ, through its direction throughout the regulation to consider climate change and environmental justice, is asking the agencies weigh those in favor of the long-term consequences related to carbon issues. There's also potentially, when an agency considers mitigation in an EIS, it now needs to be legally binding, and there needs to be an enforceable compliance plan that comes out as part of the final record of decision. So that's another way in which the CEQ is pushing towards substantive outcomes. The rule also restores those significance factors from the 1978 regulations, but with a couple of twists. In terms of context, so context and intensity were the factors that had to, the two prongs, the analysis that had to be considered under the 1978 regulations. The context factors that have been restored, originally context had to be considered in terms of national, regional, or local impacts. And so you could see an EIS looking at impacts in all those contexts to determine whether significant effects would occur. Now the regulation has added the language, changed from or to and has added the term global. And so to comply with this new regulation, if it becomes final, the agency really is going to have to consider significance in every context. In terms of intensity, the 10 factors have been restored with the addition of specifically calling out the degree of effect to climate change and the degree of effect to communities with environmental justice concerns. So now those are expressly called out in the factors. If you read through the proposed regulations, one thing that I think is striking that you notice is the repeated reference to climate change and the repeated reference on the next slide to environmental justice. And I'm not going to go through each of these and discuss them, but the basic gist of it is that it does seem to appear that through the regulations, the agencies CEQ is asking that the agencies really give primacy to these issues when they're considering the environmental impacts of a proposed action. The one that is particularly interesting, I think, is the development of alternatives and whether the agencies are being asked to, there's an encouragement, a strong encouragement to develop alternatives that reduce climate change effects. And this coupled with the greenhouse gas NEPA guidance that came out from CEQ earlier in the year and a suggestion that it would be reasonable for agencies who are considering fossil fuel projects to consider renewable energy as a reasonable alternative, has raised questions, of course, as to whether that comports with the overarching requirement that reasonable alternatives take into account the purpose and need of the project applicant. So that's one issue that we'll have to see resolved over time. Environmental justice now appears throughout the statute or the regulations. Of course, environmental justice and climate change are issues that are addressed in NEPA documents already. So this isn't necessarily a sea change, of course. Those analyses have become more involved and have evolved over time. And so we're just seeing the additional recognition of that in the CEQ regulations. I will note that the definition, thank you, of environmental justice includes the full protection from disproportionate and adverse effects to communities with environmental justice concerns, and query whether full protection, which the definition actually comes out of a policy statement from executive orders, whether full protection is actually possible, or whether as a practical matter, there's always going to be, no matter how slight, some difference in impact among stakeholders. And so there may be litigation I could see around whether the agency has adequately considered mitigation for full protection against disproportionate impacts. So I know that there are folks who have commented on full adoption of that policy statement directly into the regulations. So we'll see whether that makes it into the final rule. There are some new concepts and language in the regulations that are worth highlighting. One is an invitation, basically, to comment on whether it makes sense to have innovative approaches for NEPA for extreme environmental challenges. The proposed regulation gives some examples of extreme environmental challenges, and those might be sea level rise, wildfire risk, infrastructure vulnerability issues, and whether there ought to be innovative approaches. There's no real definition around what an innovative approach would be. And what I have heard, not from stakeholders across the board, is that there's real concern around this potential because of the uncertainty. And there's also the question that if there are innovative approaches available that make NEPA more efficient, why should there be winners and losers in terms of which projects get to take advantage of those? If they exist, shouldn't all projects have the opportunity to use efficient and innovative approaches? Another change that I think is important, no pun intended, but hasn't gotten a lot of play in some of the discussions that I've seen, is that throughout the regulation, the agency has substituted the word significant for important, and they describe it as a cleanup exercise without any substantive bearing. But important is a very value-laden terminology. It's also significant, of course, has almost 50 years of litigation talking about what that means, and you at least have regulatory factors for the agency to consider. So now requiring comparison of the proposed action and reasonable alternatives based on significant or important effects, it makes you wonder, well, what does that mean? And will that be a basis for more litigation? I just have one more minute, so I'm going to skip over this slide. This is basically a removal of some of the limits on judicial review, and the agency describes these as embodied in the Administrative Procedure Act, and so unnecessary to include in the NEPA regulations. And then my last point I would say is that the proposed rules really don't take the opportunity to implement some of the provisions of the Federal Fiscal Responsibility Act. The judicial petition process is left unaddressed. There's also zero guidance on how an applicant prepared EIS process should happen, with the CEQ basically punting on that to the agency, to each individual agency to figure out. And I think that's a missed opportunity on CEQ's part to provide some guidance around how that could happen. And then there's potential inefficiencies. That's what happens when you write new rules and you include new terminology, is that the agency now has to figure out how to implement some of those issues. I think that's all I have for now. And I did not leave time for questions, so.